Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I wanted to give you guys an update on the lawsuit between GWACS Armory and KE Arms, Russell Fagan, Sinistral Shooting Technologies, Brownells, and Sean Nealon. Now, if you haven't been following this one, you can get up to speed by watching some of my previous videos on the subject. But as a really brief overview, GWACS Armory used to make a firearm called the CAV-15. And then they stopped making it. They went out of business in terms of selling these particular firearms. And later, KE Arms, who is associated with Carl Casarda and In Range TV, who you might be familiar with, they started making a firearm called the KP-15. And this is all connected to the What Would Stoner Do project. Now, GWACS Armory is saying that KE Arms stole their trade secrets in order to make this firearm. The problem is that they've got some real issues with their case. Really what they want to do is try to pretend that they've got a trademark claim here or a patent claim, but they don't have any of those things. So, bit of a problem for them, and really they seem to be relying on a very nebulous trade secrets claim in order to try to force KE Arms out of business. And you might be wondering, why would they want to force them out of business? Well, GWACS Armory is very connected to a Mr. Oppenheimer who has indicated that he's very anti-AR-15s for the civilian market. All right, so that's kind of our rundown here. Where we're at in terms of the litigation is that KE Arms has identified a bunch of communications that GWACS Armory has had with third parties out in the world. And the reason why this is significant is because GWACS Armory is relying very heavily on these claims of trade secrets. And trade secrets are a form of intellectual property, but significantly, they require you to actually take steps to protect them. If you share those with the world, they cease to be trade secrets. A classic example is the formula for Coca-Cola. If Coca-Cola were to put that up on their webpage, it would stop being a trade secret, and that would be a big problem for Coke. So because of this, and because they've not provided these communications, KE Arms and so forth have been saying, listen, this is a really big problem. They were sharing out this information and not telling us, which has harmed us in this litigation because they were required to provide that information. So now we're going to see some response to this motion for what are called spoliation sanctions. And spoliation basically means you didn't turn over or you destroyed evidence. So let's dive right in. Hopefully that's enough of an overview for people to follow along with what's going on. If not, check out the previous videos and then come back to this one and you'll see where we're at. All right. The first document we're going to look at is plaintiff's response and objection to defendant's motion for spoliation sanctions. So this is a document filed by GWACS here and saying, we shouldn't be punished, we didn't spoliate, etc., etc., etc. And of course, it starts with the comes now, plaintiff GWACS Armory. And I hate that language. I don't know why it persists in law, but it does. All right, let's have a look. Defendant's motion falsely claims Armory withheld evidence requested in discovery. KE Arms requested Armory produce internal communications between Armory and Shell Jones from 2016 to present concerning the trade secrets and proprietary information at issue in this case. The emails at issue here, attached to the supplemental declaration of Russell Fagan, were not responsive to the document request served by KE Arms. The emails attached to Fagan's declaration are between Jones and third parties, not Jones and Armory. So essentially what they're arguing here is, nuh-uh, you didn't ask for this, you asked for something else, because these are external communications, not internal communications, and they're saying you only asked for internal communications, so whoops, you're bad. Now this seems a little odd, because in a trade secrets case, it seems hard to imagine that there wasn't a request for disclosure of any communications that might have revealed those trade secrets. And we'll get to that. I'm sort of spoilers a little bit here. But the other thing here is that normally there's a requirement to provide sort of any related documents, whether or not they're specifically requested. So we'll get to that as well. But at this point, we're just looking at GWACS Armory's response. All right. Further, the emails attached to Fagan's declaration did not disclose the trade secrets or proprietary information at issue in this case. And you might be thinking, what? If you've watched the previous videos, because they turned over a whole lot of information. They turned over details of, thicknesses of things. They turned over stuff related to temperatures. They turned over stuff related to, pictures of actual sort of raw moldings, all sorts of stuff. But they're saying, no, this doesn't connect to the trade secrets or proprietary information. And what we're going to see is that these trade secret claims keep kind of shifting, because initially those claims were very broad and expansive. Everything connected to this is a trade secret. And now, maybe not so much. They seem to be backing away from that. So, Armory's response to interrogatory number 8 states, Armory disclosed the condition of the molds, financial information of Armory, that Armory was seeking investors for continued manufacturing and development, total CAV 15 Mark II lower sales volume, CAV 15 Mark II sales following in-range videos, its intent to use Marks III and Marks IV for future CAV 15 models. I'm just going to stop here and just note, as a trade secret, this kind of seems a little ridiculous. The first one is the Mark I. The second is the Mark II. Who could imagine what the next one in line would be? I mean, we teach preschoolers to count, right? You can't trade secret counting. So you're gonna claim a trade secret over Mark III and Mark IV following Mark I and Mark II? Okay. Okay. Sure. When they talk about the condition of the molds as a trade secret, keep in mind, we saw pictures of the sort of fresh moldings out, the fresh lowers that were produced before they trimmed away any of the flashing or any of that stuff. And that really tells us how the molds are doing, because you can see the faults in that. So I feel like that one, those emails were highly relevant to. But anyway, carrying on here. Financial projections for future CAD 15 production and sales, drawings and renderings of the CAD 15, the Mark III CAD renderings and functionality improvements to include several features that were included in the KEA polymer receiver, and the Mark IV adjustable stock CAD renderings and functionality. Because the emails supporting defendant's motion were not requested by KE Arms, the motion for spoliation sanctions must be denied. Further, assuming arguendo, which means just for the sake of argument, the emails at issue in defendant's motion had been requested, the emails do not contain the trade secrets or proprietary information at issue in this case. Therefore, defendant's requested sanctions are not appropriate. I mean, here's the thing. They certainly seem to include some of those details. And if we don't have all of the emails because they weren't sharing all of those details, then doesn't that imply that there might be more out there? So I don't think that this is terribly helpful here. Defendant's motion attempts to characterize Armory's failure to produce the emails at issue as an intentional omission or concealment. Defendant's motion alleges Armory cherry-picked Mr. Jones' communications while concealing others. Now, I want to get in, I'd want to see a little bit more of what all they did produce, because if they did produce communications with Mr. Jones and other third parties, then that would kind of suggest some cherry picking here, and that their claims of, oh, well, we're only producing the internal stuff would be not so great. We'll call it not so great. That's but all right, well, this is what they're saying. They're rejecting this notion. And I'm skipping over a whole bunch in this just for time, right? Because otherwise this video is going to be 3 hours long. So I'm just trying to give you a general gist here. There's a bit of a back and forth that we're going to see between GWACS and KE Arms and so forth. And so we'll see how that sort of back and forth goes. But then we'll get to what the ultimate order is, because we do have an order issued in response to this. So Armory was unaware of the communications attached to Fagan's declaration because those communications were not requested. Jones did not communicate internally using the sales at GWACS Armory for dealer at GWACS Armory email addresses, the source of the emails attached to Fagan's declaration, so those email addresses were not searched for Jones' internal communications. But isn't Jones part of GWACS? I mean, this is a problem. Yeah. So how can you not be aware of something that Shell Jones is doing when he's, whatever. Okay. Nonetheless, as stated above, the information contained in the emails relied upon in defendant's motion are neither the trade secrets nor the proprietary information at issue in this case. Further, even if the responsive emails were requested or were relevant in this case, defendants have not been prejudiced by the same not being produced. Now, so they're saying, hey, listen, these aren't the CAD drawings. These are just the molds produced by the CAD drawings that any reasonable engineer could use to recreate the CAD drawings, which normally would be enough to blow any, blow that claim out of the water. So now, they keep saying that these are not the trade secrets, and there's some interesting aspects. I'm actually not going to go through all of it, but one thing, and sorry, I'm going to sort of cut a bunch of stuff here, but one critical aspect to this that they're going to go through is they're going to say, listen, all of that information that we provided to those other people is not correct in some fashion. So they're going to go on and say, do you remember how we said that there is a 0.135 width? Well, nothing in there is precisely 0.135. So that information was not accurate. They say we gave this length measurement of 1.5 inches, but that's not the precise amount. So that's not accurate as well. Maybe, but I mean, you still should have provided those documents so that could all be determined and tested and looked at. The fact that they didn't provide this is a problem because normally you'd have to share this. There's also an interesting argument. They're saying that the ribbing in the CAV-15 Mark II production model is not the same ribbing as used in the KP-15. The ribbing for the KP-15 was taken for the CAV-15 CAD files. Defendants misappropriated the ribbing design, which only exists in the CAV-15 CAD files Armory purchased from Russell Fagan and Sinistral Shooting Technologies. But the problem is that if they're sending out pictures pretty freely of the ribbing designs, then, I mean, maybe they're sending the ribbing designs to all sorts of other people. It's like, this is highly relevant to things that you might ask in questions in... So, yeah, I don't think that this is terribly strong. There's other places where and I'll just sort of bring this up here. They'll note that the CAV-15 is not made of 20% glass-filled nylon 6, and Armory did not tell Blankenau whether the glass was long glass or short glass. Now, I'm not a polymer expert here. I did talk to somebody who works with polymers, and they said basically, hey, this is not a hard question to figure out. There's only actually one answer to this as to what you would use. Now, I don't remember whether it was long glass or short glass. It was a while ago that I talked to them. It was back when this document came out, which was actually a little while ago, and I've been busy. But yeah, even if we assume that either of those two things is possible, it's 2 entries. And how difficult is it to try it with long glass, then try it with short glass, and see which one works better? 2 things, right? So it's kind of interesting when they're saying, hey, listen, these details that we are sharing out are false, but it still matters that they're sharing them out. And I feel like there's some interesting kind of, and I can't say for certain, but it feels like there's some sort of twisting as to which models they're talking about, and that some of these things may have changed over time. But regardless, I don't think that this really helps them all that much in terms of, hey, listen, you guys weren't providing all these documents, because a lot of the stuff they're going nuh-uh about is the stuff that would have precisely been tested and been at issue had they produced all of these documents. This is why those documents need to be produced. And you can't just say, well, they're not accurate, so we didn't have to produce them. That's all the more reason why they should have been produced. All right, we're going to look at another document here, and this is also from GWACS Armory. And this is Plaintiff GWACS Armory's LLC's objection to defendant's motion for leave to supplement their dispositive motions. You're probably wondering, what does that mean? That's lawyer talk, and I hate the way lawyers talk, and me too. I really wish that some of this stuff would be more clear. So KE Arms has applied for summary judgment. They want to throw out GWACS Armory's claims entirely, and that's still waiting to be heard. And they're saying, so KE Arms has said, listen, because we've got all this new information, we need to be able to amend our motion for summary judgment in order to put that stuff in. We need to, had we had all of this stuff, we would have included that, and we didn't, so we want to put that in and, argue that as part of that motion. And GWACS Armory doesn't want that to happen for reasons that probably seem fairly obvious at this point. All right, and once again, they start off with, comes now. Yeah, I always say it sounds like a Victorian porno, and I hope that language catches on, because it might embarrass lawyers into stop, to not do this. Maybe if I get enough money, I will fund like a legal porn parody, just to mock the hell out of that, and then send it to every lawyer who files a document with comes now if it's not actually required by their local rules, just to make it into a joke. Like, let's just make this into a complete joke, because I hate that language. All right. Things I would do if I had unlimited money. Defendant's motion falsely claims Armory withheld evidence requested in discovery. KE Arms requested Armory produce internal communications between Armory and Shell Jones from 2016 to present concerning the trade secrets and proprietary information at issue in this case. So once again, they're saying these aren't internal communications, they're external communications, so we didn't have to turn them over. They also say furthermore, one complaint lodged in defendant's motion is that Armory failed to disclose emails with Timothy McBride. Defendants claim the McBride emails were forwarded to defendants on October 8th, 2022. However, defendants knew of and had contact with McBride well before filing defendant's motion. So this is saying, hey, listen, you shouldn't let them put that stuff in, because they should have already known this, and so that's on them. And you know what? This claim might hold some water, but really they should have still provided those emails. And also notably, it was defendants who failed to disclose McBride's knowledge and information in discovery. Okay, bold move, Cotton. Let's see how that one plays out. All right. So they also note defendants had contact with McBride well before the briefing of dispositive motions, yet they did not include any evidence from McBride therein. Similarly, defendants had the emails from Kenneth King on July 19th, 2022, and they filed their reply briefs but did not attach those emails as evidence, despite having the same well in advance of filing their reply. Okay, that's not terrible as arguments go. I mean, they can say, listen, this should have been in there because they had it beforehand. However, they also note this resulted in people sending emails the defendants never requested for Armory in this lawsuit. Nonetheless, the emails defendants seek to rely upon are not relevant to Armory's claims in this case, do not impact the outcome of the pending motions for summary judgment, and defendant's motion should be denied. Now, if they're not relevant, then why do you care that they go in? This one, like the whole fact that you're so objecting to them going in, kind of suggests that maybe there is some relevance, and there's some relevance, and you're trying to pretend there isn't. There is something to be said for, hey, listen, we don't want to have to reply to, this new edition, but I feel like this kind of undercuts their own arguments as they make it. Yeah, So I'm going to skip over most of that just so that we can get to the response here, because I want to cover that and still sort of have some time for discussion, because this, I think, is interesting. It's we're going to see, you've seen a little bit of sort of what GWACS's position is. Now we're going to see the response, and there's going to be a little bit of receipt checking. So let's dive in here. So defendants reply in support of their motion for spoliation sanctions. You know what I love here? You know what I love about the start of this? Defendants KE Arms, LLC, Russell Fagan, Sinistral Shooting Technologies, etc. No Victorian porno language, which tells me two things. First, that language is probably not required by the local rules of court. And second, that these lawyers are not just riding this old tradition for no reason. So good on you. I approve of that. That has nothing whatsoever to do with the case or the likely outcomes. That just has to do with my preference. But man, do I have I really don't like the comes now language. It's so ridiculous. It's been ridiculous ever since we had vehicles that weren't powered by something that eats grass. So, yeah. All right, overview. It is now undisputed that GWACS Armory withheld electronically stored information, which they're going to call ESI, and the identity of at least 10 witnesses in discovery. Because they didn't dispute that. They just said, okay, well, we didn't provide it to you for a bunch of reasons. But, yeah. Armory's opposition attempts to justify its unilateral decision to conceal evidence in this case in essentially three ways. So the unilateral decision is kind of snarky language, because in court proceedings, you typically don't get to make a lot of unilateral decisions. A lot of decisions have to be made via the courts or with consent of the other side, and disclosure and discovery typically have a lot of those kinds of decisions that have to be bilateral as opposed to unilateral. All right. First, Armory argues that none of the emails withheld by Armory were requested in discovery, despite the fact that request for production number 60, expressly requested the production of this ESI. There's a missed word here, and one thing I will note about KE Arms' counsel, you guys got to do more proofreading. There's a number of places where you miss words and so forth. And I don't know about the court you're in front of. Some courts really don't like that. So be more careful, guys. Come on. In fact, Armory even responded to request number 60 without objection while simultaneously concealing responsive ESI. Armory's assertion that the evidence it withheld was not requested is a blatant misrepresentation of fact. So I said that the unilateral decisions was kind of gentle snark. Blatant misrepresentation of fact is more of firing the broadsides. That's a big allegation, so let's keep going. Second, Armory argues it withheld the evidence because it unilaterally decided the evidence was not relevant to the claims and defenses in this case. Again, we're seeing that unilateral language. But the evidence is relevant, and in fact it concerns the same Cat 15 features that Armory presently claims to be trade secret and proprietary on summary judgment. Further, Armory's determination of relevancy does not justify its unilateral decision to conceal evidence, especially when Armory responded to request number 60 without any objection. Now we're going to talk about how you deal with irrelevant documents a little later, and the reason why it's a little later and not now is because this response actually covers some of that, and so otherwise we'd be looking at doing it twice. So Armory is not entitled to produce only some documents and withhold others, depending on its own ex parte determination of relevancy. Now, ex parte is, again, that's another way of putting the unilateral language. It's saying without the other side. And I kind of like the way they did that, because you're only allowed to make ex parte applications in some circumstances, and this probably isn't one of them. Third, Armory attempts to feign ignorance by arguing it was unaware that the witnesses in ESI withheld even existed. But this argument is not supported by the declaration of Armory's own Vice President of Sales, Michael Jones, who openly admits he corresponded with each of the 10 unidentified witnesses using Armory's email address. Yeah, we're unaware of this, but also these emails are from me personally. So how does that make any sense? In fact, Mr. Jones admits to having possession, custody, and control of each of the Armory Company's email addresses that he used to correspond with the unidentified witnesses. Thus, Armory was not only aware of the evidence it withheld, but it also intentionally withheld the evidence after it was requested. Ouch. That's gonna sting. In all, the full extent of Armory's abuses of the litigation process are still unknown. And this is the point I was making before about if you're not providing all of these emails, then how many more emails are there? KEA Arms is trying to find out how many emails there are by canvassing the planet to figure out who all sent emails. But the appropriate way to find that out is actually via, GWACS providing this information. This is in fact the reason why the discovery process exists. This is the whole point of the discovery process. So, yep. Armory's attempts to suppress information are only further evidenced by its failed attempt to impose a gag order. I love how they're turning the gag order attempt against GWACS here, because this really, I think that they're really making a good argument here, which would have prevented third parties from learning of the litigation and coming forward with additional information. The only way KE Arms finds out about, about all of these extra documents is because of the public being aware of this litigation and sending those documents in. But Armory then, once they see this is happening, instead of going, hey, listen, we're going to, respond, because they never responded to those to those discussions going, hey, we're missing some documents. What's going on with that? They instead go and they say, we want a gag order. So we want to prevent all of you guys. They're trying to shut down KE Arms' ability to get this information. That, I think, is kind of telling. So Armory's intentional suppression of critical evidence is undeniably prejudicial to defendants. Such prejudice warrants terminating sanctions. So terminating sanctions is basically sanctions that end the case. Alternatively, Armory should be precluded from offering evidence that its information was not publicly known, and/or the jury instructed to infer or presume that Armory publicly disclosed its own trade secrets and proprietary information. So they're asking for the big asks here. They're saying, either you should just tell us we win, or else you should ban them from offering the evidence that would tell the jury that we shouldn't win. I think either of these things really ultimately leads to, if they get what they're asking for here, ultimately all roads lead to, KE Arms and so forth must win this case. All right, let's keep going a little bit here. Armory falsely asserts in its opposition that none of the emails it withheld in discovery were requested by defendants. Remember how they said, oh, you guys only asked for internal stuff, not external stuff, so we didn't have to give you the external stuff. Here's where we're going to get some receipts. But KE Arms request number 60, undisputedly served on Armory, expressly requested, produce all of your communications in native format of Shell Jones concerning your trade secrets referenced in paragraphs 59 to 67 of the complaint, or proprietary information identified in response to interrogatory number 8 during the relevant period. Doesn't say internal. Doesn't say you can not provide the external. It says everything that is related. So that's a problem. They've just filed a document saying, hey, they only asked for internal communications, and now we're seeing, nope, they asked for everything about Jones. So, whoops. So, tellingly, Armory even responded to request number 60 without objection, while simultaneously concealing other response of ESI. Even if, arguendo, the ESI had not been specifically requested in discovery, which it was, Armory still had a duty to disclose the information under Rule 26, because the ESI directly concerns the same features of the CAV 15 Armory presently claims to be secret and proprietary on summary judgment. Therefore, Armory cannot legitimately dispute the evidence was both requested and discoverable. All right, let's have a look at Rule 26, because they've got it quoted right below, and it's going to be helpful to us here. So it provides that a party must, without awaiting a discovery request, so whether or not you get a discovery request, you still have to do this, provide to the other parties electronically stored information that the disclosing party has in its possession, custody, or control. So that kind of suggests that they still have to provide it, even if it's in their control, even if they don't have a request. So that whole sort of silly buggers game that they're playing of, hey, you know, your request was, you asked for the wrong thing. Well, it wouldn't have even mattered if they didn't ask for anything pursuant to Rule 26. Whoops. All right. Armory cannot unilaterally determine the relevancy of the evidence it withheld, especially when it is presently asserting the evidence is to be relevant on summary judgment. All right. So this is going to be where we get into how you deal with this relevancy issue. Armory argues that request number 60 sought information that was objectionably outside the scope of discovery. There's a key word here, and I really like how they did this. Objectionably. So that it was objectionably outside the scope of discovery. All right. Problem with something being objectionably outside the scope of discovery is that you have to do a thing about that, which is you got to object. Yet Armory responded to the request without objection and waived any potential objection as to relevancy. And I'm guessing that the waiver of objection was just by not objecting. So indeed, a party resisting production bears the burden of establishing a lack of relevancy, which means that's something you've got to do in court. If you want to say, hey, listen, we don't want to turn these things over because they're irrelevant, you have to establish why they're irrelevant. And any objection to a request for production must state whether any responsive materials are being withheld on the basis of that objection. So if you want to not produce something that is, you know, because it's not relevant, you have to actually assert that and say why it's not relevant. And they didn't do that. They just didn't say that it existed at all. Here, Armory did not even object, let alone notify defendants it was withholding evidence. Right? Armory's belated objection as to relevance in its opposition was never raised and has long since been waived. And again, I'm pretty sure that's just because you have time limits to raise those kinds of objections, and they just didn't do that. So this can be the danger of just hiding information, because now they may have waived those objections. Rather than object and notify in discovery, Armory opted to conceal that it was withholding responsive ESI. And they note, if Armory actually believed request number 60 sought information beyond the scope of discovery, then it should have objected or sought a protective order. But they didn't. So to be sure, there is no middle ground, and this is quoting from a particular case, there is no middle ground entitling a responding party to produce some documents and withhold others, depending on the responding party's ex parte determination of relevancy. Man, that quote seems real on point, doesn't it? It seems really accurate to what they're dealing with here. Conversely here, Armory argues that it was somehow entitled to silently object to request number 60 by simply concealing the responsive evidence, which is, of course, obviously not how things work. In a word, Armory is not entitled to make its own ex parte determination of relevancy. Now, I don't really like the in a word here because it's multiple words. Multiple words here. I mean, if the worst criticisms I have are, you know, some editing issues and some turns of phrase, then you're doing pretty good. But still, that just, it rubbed me the wrong way. I mean, if I was a judge and I saw that, I would make a frowny face and move on, because you're not going to rule against somebody based on something like this. But it is one of those things that just my brain catches and I go, really? All right. Moreover, the obvious problem with Armory's abuse of the discovery process is that it severely prejudiced defendants. Armory's decision to unilaterally conceal evidence made it impossible for defendants to evaluate or identify the breadth of Armory's public disclosures of its alleged trade secrets and proprietary information. Because, of course, those might extend way beyond what we actually know. There might be additional public disclosures that they don't know about, because, once you find one hidden landmine, that tells you that you're not, it's probably not just, oh, there's one landmine here. That probably tells you that you're dealing with a minefield. And now they're saying, hey, we have to go play Minesweeper here to determine how many disclosures there are, because you weren't, open and honest about that. All right. Unfortunately, the withheld information presently before the court is only what defendants obtained through third parties who voluntarily came forward with their communications with Armory. Armory's attempt to suppress information is only further evidenced by its failed attempt to impose a gag order, which would have prevented, and it says which would have prevent, again, guys, you can't just run spell check and call that good enough. Check your typos. Which would have prevented third parties from learning of the litigation and coming forward with additional information. At this stage in the litigation, it is impossible for defendants to determine how many other public disclosures were made by Armory and its agents related to the CAV 15. Right? Because otherwise they could have dug into this and they could have looked at all of that stuff and tried to find out how many times this happened and what exactly was detailed. Because we saw Armory's response saying, hey, listen, we didn't disclose this thing, and we didn't disclose that thing, and we didn't disclose the other thing. So those are still... How do we know you didn't? Like, how do we know if you didn't actually provide all of this stuff? And if you keep backing away from your... from the sort of expansiveness of your trade secret claims, how do we know that stuff wasn't provided? It's the minefield problem again, right? So, regardless, the ESI withheld by Armory is relevant. In fact, the ESI concerns the same features of the CAV 15 that Armory is presently claiming to be secret and proprietary on summary judgment. For example, Armory argues that it withheld the communications with Mr. King because the ribbing in the CAV 15 Mark II production model is not part of Armory's alleged secrets and proprietary information. Yet, on summary judgment, Armory claimed that the internal rib design of the CAV 15 was indeed part of its alleged trade secrets and proprietary information. Specifically, Armory states, remember how I said that they seem to be backing away from their trade secret claims every time they get caught on something? Well, this is really showing some receipts on that. The internal rib design of the CAV 15 is clearly business, scientific, technical, and engineering information that includes patterns. I don't know if that typo is in the original one or in this one. Designs and prototypes. Some people don't like the use of the sort of quotation mark or the quotation editorial designation of SIC, S-I-C. And this is really the place where you'd want to pull that out, because I've seen several typos in this reply. And so I don't know if this typo is something that they are faithfully reproducing from the original, or if this is a typo that is on their end. And you don't want typos in quotes. That is really potentially a bad thing. So I think that this is another problem where what I see is they're using spell check for correction, but they need to actually go through and read their documents. Somebody's got to be reviewing these. I'm sorry, but there's just too many here for me not to make a comment on this. Sorry, guys, but this is something you got to work on. Designs and prototypes. The internal ribbing pattern is neither standard nor uniform. The design of the CAV 15, including the internal ribbing, derives economic value from not being generally known, which is evidenced by the fact that prior to the KP15, the CAV 15 was the only viable monolithic polymer lower receiver, and then we're going to hit some really key words here, on the market. So, if Armory was not claiming an interest in the internal ribbing to the CAV-15 Mark II production model, then why did it argue it derived economic value from being the only viable monolithic polymer lower receiver on the market in summary judgment? Because it's on the market, right? In a word, Armory cannot take a new position on this issue to avoid sanctions while it is presently asserting the same information to be a trade secret on summary judgment. Boom. Boom. This is really calling them out for, you guys can't keep backpedaling from your claims. And yeah, I don't think the court's going to like this. I'm not saying I don't think they're going to like the reply. I don't think they're going to like what GWACS seems to be doing here of, basically bullshitting about what they're actually claiming as trade secrets. Because at that point, the court is going to be sitting there wondering, how do I trust you on what you say your trade secrets are at all, right? Is this just that you're saying things are trade secrets as is convenient for this litigation? Because that's a problem, right? Okay. Finally, it is abundantly clear that Armory withheld the emails in discovery because they directly contradict the testimony of Armory's Rule 30 sub B sub 6 designee, Judd Gudgel, who stated that it never publicly disclosed its alleged trade secrets and proprietary information. This is also a major broadside, right? Because this is saying, hey, listen, this isn't accidental. This is you concealed stuff that is really key here. If Armory's disclosures to third parties were not relevant, then why did Mr. Gudgel bother to make this statement on summary judgment at all, that they never publicly disclosed any of this information? These highly relevant emails with Mr. King and others establish public disclosure of Armory's alleged trade secrets and proprietary information. They are not only relevant to Armory's trade secrets claims, but they're also relevant to the breach of NDA claims because both NDAs in this case expressly excluded any information in the public domain, which means once GWACS sends it out to some random member of the public, it's in the public domain because that random member of the public has the right to do anything with it. Like they could put it on Reddit. They could email it to some further third party. They could put it, they could hire a blimp to tow a sign with it. They could put it up on billboards. They could have, people waving signs with this on the street, whatever they wanted to do. They could make a YouTube video with it. So, yeah. Indeed, concealing the emails allowed Armory to maintain its assertion on summary judgment that it never publicly disclosed its alleged proprietary information outside of the 2015 and 2018 investment packets disclosed to KEA and Brownells under the NDAs. Which, if that's false, is a really big deal, right? In all, Armory's decision to withhold emails in discovery was deliberate, it prejudiced defendants, and it is sanctionable. All right, so you already get the impression here that I kind of feel that they dropped, that I kind of feel that the reply here did a lot more damage than GWACS's response. So let's have a look at what the court does with this, because you might be surprised. And I'm going to try to read between the lines a little bit, and I'm going to lay out sort of how I'm reading between the lines and where I think, where I'm going to note where I'm speculating and why I'm speculating, but let's have a look. All right, so now we have the order, and I'm going to skip over because there's a whole lot of review of the reasons for the order that we just covered. So if you just were watching the rest of this video, we can skip over that because you've seen it. Plaintiff filed this case alleging that defendants violated non-disclosure agreements by developing a new product using proprietary information or trade secrets that were disclosed to defendants pursuant to the non-disclosure agreements. A key issue in this case is whether the information disclosed pursuant to the NDAs was actually proprietary information or trade secrets, and defendants argue that new evidence shows that plaintiffs made public disclosures of the information without any safeguards or attempts to maintain secrecy. Plaintiff disputes that defendants specifically requested this evidence in pretrial discovery, but the court declines to consider a discovery dispute at this stage of the case. So I'm not going to hear this issue right now. However, the new evidence was discovered after defendants' dispositive motions had been filed, which contradicts, like, this goes against what GWACS has been saying, right? So the court is disagreeing with them there, and the new evidence is potentially relevant to the court's ruling on those motions. Now, the court's using some sort of, the court doesn't want to show its hand, right? But noting that it's potentially relevant to the court's ruling on those motions, GWACS was just arguing that it wasn't. They were just arguing this is completely irrelevant. If the court agreed with GWACS on that, they wouldn't be making these statements. The court finds that defendants' request to supplement the summary judgment record is granted, and the court will permit plaintiff to file a brief supplemental response addressing the new evidence. And in fact, they get very short time limits on this. Defendants may file supplemental declarations no later than January 4th, 2023. That's real close. And then the supplemental response, not to exceed 10 pages concerning these supplemental declarations, has to come in by January 6th. They get 2 more days. So better get started pre-writing on this one, because you got 2 days to adjust it to whatever comes in on January 4th. Now, the court isn't saying, hey, listen, here's what we're going to do. So I am admittedly reading between the lines here. But the court is saying, listen, I'm not going to address the sanctions issue and so forth at this point. However, I will let you amend some things on your summary judgment application. I have a feeling that the summary judgment application might be a good day for KE arms and so forth. That is what I'm reading kind of as a potential hint here. Now, there's no guarantees. Like, I can't say, hey, they're definitely going to win here. But, I mean, if I was KE arms' counsel, and I'm not, you know, I have no connection to them in terms of, you know, financial or legal advisor or anything like that. I will note, I'm on the InRange Discord, you know, I'm a Patreon supporter and so forth because I like the channel. I mean, I also support several other channels, but this is, I feel like I would be sitting there thinking, this is a good day. I probably would have been, you know what, this is a celebration scotch kind of order. Because this to me says the court thinks that this is a, you know, the court doesn't think that this is a nothing burger. The court isn't sitting there going, yeah, okay, who gives a damn? And there's certainly, they don't seem to be agreeing with GWACS's notion that this is, oh, you know, this never had to be produced because of internal, and that besides it's irrelevant because, you know, this doesn't cover our trade secrets. If the court thought that this didn't cover things that were currently being claimed as trade secrets, they wouldn't be saying, hey, you can file this as a supplemental. So the court clearly seems to think something's going on here, and I'm going to be eager to see what their response is. So I'm probably going to hold off until after I've got both replies, because 3 days from now we're going to get you know, KE Arms's amended details, and then on the 6th we'll get the GWACS response. You know, I'm going to do another video to cover those details because counsel is also getting a little spicy with each other at this point, and I'm entirely here for it. All right, so thank you guys for watching. This provides sort of the update. There were some people who were asking what's going on with the spoliation, you know, issue. Now you know what's going on with the spoliation issue. And so I'm really eager to see how this one goes. I think it could be a lot of fun. So we're going to keep following it. All right. Thank you guys for watching. I want to thank as well my Patreon supporters at the $50 level. And if you want to join them, there's a link in the description below. At the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association, as well as David Michaud. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Mark, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who are in the crawl immediately following. Thank you guys for watching. I hope this has armed you with knowledge. See you next time.